two very interesting cases about what is defined as recklessness. And I must tell you, I didn't really realize that an insurer could decline a claim based on recklessness. I'd never really thought about it. But you had quite an interesting case where a chap, he was driving 100 kilometers an hour through a residential area. It was low light, not great lighting. He hit a pothole, flew along, hit a street light, wiped his car out, damaged his car, and the insurer said that was reckless driving, and you said yes. How do you decide that he was being reckless?
So we rely a lot on the criminal law, because in the civil law and the contract of insurance is based on it's civil law, it's not criminal law. And we also there's one leading case that has been in existence for many years that guides us on how to determine recklessness. And it's all a question of foreseeability. What would the reasonable person in the insured's position have reasonably done in the circumstances? Would that person have foreseen that had he continued with his or her conduct, there was a risk of a loss taking place and damage occurring or not? So that's to put it very simply. In this particular case, it's at night, there are potholes, which the insured says he saw in the road.
He was near home, so he wasn't aware those potholes existed.
Yes, exactly. Yeah. He, at one stage, also said that he thought he was being followed by a suspicious vehicle. When we called for the evidence, now the insurer bears the onus of proving and discharging the proof that its rejection is correct. So it needs to provide evidence. How did it get to that conclusion? And often there'll be expert reports. So although the insured had said he saw the potholes and tried to swerve around them, and there was this vehicle that was chasing him, a suspicious vehicle, he thought that they were going to hijack him. The reconstruction report and the data that gets downloaded from your vehicle and the tracking report didn't support the insured's version of what he was saying. There was no swerving. There was no attempt at trying to evade this vehicle. There was just consistent high speed. So in other words, the insurer was able to show that this driver had been consistently driving at a very high speed in these circumstances, whereas the insured had nothing to support his submission that, first of all, he had tried to swerve the potholes, try to avoid them, and that there was this vehicle chasing him. So it's all about the evidence and the quality of the evidence and the quality of the experts and their experience, their qualifications, and we weigh up this evidence, and that's why we're able to determine on a balance of probabilities that the insurer's version is more probable than the insured's version.
I think it's a really great case to have discussed, because I think that's important for listeners and for consumers to hear how much detail goes in to adjudicating these cases. Because I think there's a sense of like, yeah, well, you work for the insurers and, you just don't like me and you don't trust me. And, but when you hear that, you actually call on evidence. You look at these cases because, one of the things that also come up often is the drinking and driving. If you are drinking and driving, that's proven. Is your insurance completely is the claim null and void?
Absolutely. So it's not just a question of driving under the influence. It's driving under the influence to the extent that it impaired your driving ability. Okay. So insurers have quite a long way to go before they're able to successfully reject those.
So a glass of wine may not count, even though it's above the law?
No, it may not, because they have to show how that alcohol influenced your driving ability. So it's not easy for the insurer to discharge that onus to prove its rejection, and there's a lot of investigation and inquiries that get done. Witnesses, often there are no alcohol blood test results because people are able to leave the scene of the accident without any witnesses. So it's a huge investigation. And then when it comes to our office, we analyze all of that evidence. We don't just take the insurer's word for it. We will interrogate that evidence and see, does it say what the insurer says it says? Because sometimes it doesn't. The insurer is saying to us, but look, clearly he was under the influence and that's why the accident happened. And then we analyze it and we say, that's not what we're seeing here. We don't agree, and then we make our decisions.
Talking on a cell phone, if you're talking on a cell phone and crash, is that reckless?
It depends on the circumstances. It could be just negligence. So the tip between negligence and recklessness is a very fine one, and that's all about the facts of the particular matter. What is the insured saying happened? And again, when you are describing an incident, you always have to be truthful and open and honest, because if you then get caught out, the insurer is going to have the right to reject your claim on a misrepresentation.
That is so important, misrepresentation, because there it's just, that's it. We don't have to pay now because you lied. So a very important point I think we need to add to that is be honest. Have the Ombud who will look at the case, but the minute you've lied and falsified information, then the Ombud can't do anything for you. I think that's important. I just want to end off with a very interesting another one around recklessness, because this could have gone both ways. So there's a man, he's driving his car, it's a call of nature. He gets out his car, leaves it on the side of the road with the keys in the car, engine still running, quickly goes to take a pee under the tree, and he gets hijacked. But in this particular case, the insurers are saying he was reckless. He left the car running, keys in the car, that is reckless. But you didn't agree because of the way the hijacking took place.
Yes. So had the vehicle been stolen while he went to relieve himself, we may have agreed with the insurer that that was reckless. Leaving your vehicle in the middle of the night, running, engine running, and you leave your vehicle on the side of the road, especially in South Africa. I think the test of recklessness for South Africans is a little bit different to maybe in other countries where crime is so prevalent. So it wasn't a case of it being stolen. He returned to the vehicle. As he was getting back into his vehicle, he was held at gunpoint, and they tried to force him into the vehicle. He managed to get away, and they drove off with the vehicle. In those circumstances, we did not think that the insurer had proven recklessness. He may have been negligent in that case, and the insurer agreed and then agreed to settle the claim.
Okay, but I mean, it's so interesting, and this is why we need you, right? Because who knows, how do you argue those different points? But I mean, anyway, just a really good point, do not leave your keys in the car with the car running when you go and relieve yourself. I think that's probably just a good one to take away from that.